Let's talk about the reasons to object. There are essentially three reasons, I believe. Certainly there are other reasons that are stated from time to time in our literature, but I think there are three primary reasons. The first and foremost is to exclude prejudicial evidence. That should be fairly obvious. Where there is a recognized objection in the law as to evidence that is prejudicial to our case, it is our duty to make that objection. When we're doing that, we need to remember to tie our objections to the theme and theory of the case, or if you will, the story of the case, the story of the family. For example, there may be a legitimate reason to object to something, but it doesn't serve our theme and theory to make that objection. It may hurt our theme and theory to make that objection. So in those instances, we may strategically choose not to do that. So always remember to tie your evidentiary objections to the theme and theory of your case. A second reason to object is to protect your witness from inappropriate behavior. This typically occurs on cross-examination, that is where opposing counsel is cross-examining our witness, and their behavior becomes inappropriate in the sense that they are what we think of as badgering the witness, which really means that they are being argumentative. So more often than not, the objection there is argumentative. They are trying to place a conclusion, a value judgment, almost a morality decision on the client, and that is inappropriate. And so we have an opportunity to stop. We have an obligation, rather, to stop that. Let me say at this point that there is no objection called objection, Your Honor. This guy's killing me. Objection, Your Honor. If I let this go on, I'm going to lose my case. Sometimes effective exams hurt us badly, and the only thing we can do is sit still for it, or perhaps attempt to rehabilitate on redirect. But that is not being hurt by an exam is not cause for objection, and I think it's unethical to make that objection. The third reason to object is to protect the record. The federal rule of evidence is very clear in this regard. Failure to object waives any right to appellate consideration on that matter. Now, there's an exception to that rule, and it's called the plain error rule. Some things are so clearly erroneous that they can survive in the record without objection, but my teaching point on this is to never even bother with that analysis. It's too dangerous. If you find yourself on appeal needing to make that argument, then by all means make that argument, but assume for the purposes of trial conduct that you must make an objection as to everything that is objectionable. The federal rule goes on to explain to us that the objections must also be timely, such that they are made as soon as the objectionable nature of the question becomes apparent. And we'll talk a little bit more about that when we get to specific kinds of objections.